Hello, everyone. Welcome to our third session of our Advocacy Cafe series. My name is Shauna, and I'm with the New Mexico Coalition Against Domestic Violence. We also have Caitlin McDonald here with the coalition, who's going to kind of be helping out with the logistics. And then I'll introduce to you our trainer in just a minute. Just a reminder that this presentation is about an hour and a half long, give or take an hour and a half. The first hour will be kind of a formal presentation, but we encourage your questions. So please make sure you're putting those questions in the chat box, and we'll try and navigate those questions as best as we can. And then in the end, we'll unmute everyone, and that'll give you an opportunity to ask questions live or just bring up any issues you're having. That'll be a great time to do that. So I'm going to now just a reminder that please make sure after the webinar we'll send out a survey, complete those surveys, and then you'll get a certificate of participation for participating in the webinar. So I am now going to just turn this over to Edna Sprague, and she is our guest speaker today, and she's going to be talking to us about orders of protection and giving us an in-depth look into that. So I will pass it over.
Thank you. Hi, everybody. So I want to make sure, first of all, that everybody can see the slideshow, and I think you can. So I'll just tell you a little bit about myself. I've been an attorney practicing about 18 years. I started my career at New Mexico Legal Aid, and I then became a district attorney for about 10 years, prosecuting felony intimate partner domestic violence crimes, homicides, rapes, batteries, all plethora of criminal cases. And then in 2015, I left the DA's office and I came back to New Mexico Legal Aid and started a domestic violence, well, I didn't start, but I was working with Sarah Coffey on a domestic violence helpline, which is a statewide domestic violence helpline. And I'll provide the phone numbers for that at the end of this presentation. And then eventually I moved up within the organization, and I'm now the statewide litigation director, but I still specialize in domestic violence. I think there are all manner of different people on this. Let me see if I can tell who's here. Whoops. It looks like we have all kinds of different participants. So please feel free at any time to jump in, and I think you would have to, raise your hand or request to ask questions, or I'm not sure exactly how that works. So I'll let the moderators manage that. So domestic violence orders of protection are found under New Mexico statutes, section 40-13-1. There are sort of 4 different types of domestic violence orders of protection, and every person calls them different things. And for me, it's always important that people use the correct terminology, because the correct terminology helps me know what I'm dealing with if somebody's talking to me. So I call them OFPs, which stands for Order for Protection. Some people call them OOPs, Orders of Protection. Some people call them restraining orders. Sometimes I call them restraining orders. Some people call them TROs. TROs stands for Temporary Restraining Orders. And then there are EROs, which stand for Emergency Restraining Orders. And those are issued by law enforcement. So I'll go over how that works in a second. If I use the term no contact order, I am talking about either a criminal case or a domestic matters no contact order. And the difference between DM or criminal case no contact orders and domestic violence orders of protection are mainly have to do with enforcement. So in domestic matters cases, if somebody enters a no contact order, it can have similar language to domestic violence OFPs, but it is not enforceable by law enforcement. Same with criminal no contact orders. Criminal no contact orders typically say that a defendant shall not have contact with any witnesses or victims who are the subject of their criminal case. And many people think that because a no contact order is issued in a criminal case, that they are therefore enforceable by law enforcement, and they are not. So enforceability means if there's a violation of the no contact order, can the police arrest the offender upon probable cause to believe that a violation has occurred? And for no contact orders, whether they are criminal or in domestic matters, those are not enforceable by law enforcement. So to enforce those, the district attorney in a criminal case or the client victim or his or her attorney in the domestic matters case would need to file a court motion requesting that the person who violated be held in contempt of court. So they are not immediately enforceable, meaning that if there's a violation, law enforcement cannot go out and immediately arrest the violator. Whereas with domestic violence OFPs that are issued pursuant to this statutory section, law enforcement shall arrest, shall enforce upon probable cause to believe that a violation has occurred. So I'm going to be talking about domestic violence orders of protection, and I'm happy to discuss strategies about when to enter domestic matters orders, no contact orders, but the focus of this is going to be on orders of protection issued under the statutory 40-13-1. So levels of orders of protection. Emergency restraining orders, EROs, can be issued by law enforcement on scene. So law enforcement gets dispatched to a domestic violence incident. The law enforcement officer has probable cause to believe that an act of domestic violence has occurred. Whether the offender is there or not, they can issue a emergency restraining order. The emergency restraining orders are valid for up to 72 hours, but automatically expire on the first business day after the emergency restraining order was issued. So if law enforcement goes out on a Friday evening outside of court hours and issues an emergency restraining order, that restraining order is only valid until Monday, when the victim should go into court and file a petition for a domestic violence order for protection, at which point they would be issued, were it granted, they would be issued a temporary restraining order. EROs are issued, like I said, by law enforcement. Law enforcement telephones an on-call judge, reads to the judge the basis for which they're seeking that emergency restraining order, and the judge decides whether or not there is probable cause at that point to believe that an act of domestic violence has occurred, and the judge approves telephonically the emergency restraining order. Temporary restraining orders are issued by the court after a victim goes in and files a petition for a domestic violence order for protection. And each judicial district is different in how and when and why they issue those temporary restraining orders. The statute requires that there be probable cause to believe that an act of domestic violence has occurred as defined by the statute. Now, let me just add that victims of sexual assault who were not intimate partners and victims of stalking who were not intimate partners can petition the court for domestic violence orders of protection. Those orders of protection are still called domestic violence orders of protection because the authorization for those orders of protection still fall under the domestic violence statute. fall under the Family Violence Protection Act. So a lot of times sexual assault or stalking victims will say, I'm not in an intimate relationship with the person who raped me. And I say, yes, I understand. And then I explain to them how it still falls under the domestic violence statute. So just because we call them domestic violence orders of protection doesn't mean that we believe that only intimate partners or people who fall under the household members definition can apply, because stalking and sexual assault victims can. So temporary orders of protection are issued by the court, and they are typically only valid for 10 days, the end of which the court schedules a hearing, which would be the evidentiary hearing for the court to hear evidence proving that an act of domestic violence occurred or not. Now, the Second Judicial District Court has been issuing temporary restraining orders in cases where I don't necessarily think that the petition establishes probable cause that an act of domestic violence has occurred. I think that the court is doing that because they have taken the position that they should issue them in any instance where a person petitions believing that an act has occurred. But just because a person thinks that an act of domestic violence has occurred doesn't mean that one actually has occurred. So each judicial district is different. The courts do have the ability to hold a hearing within 72 hours and order that the petitioner come back to court ex parte, meaning without the opposing party, and take testimony from the petitioner for the court to decide, by eliciting testimony from the petitioner, whether or not an act of domestic violence has occurred, which would result in the issuance of a temporary restraining order. The Second Judicial District, which is Albuquerque, has not been doing that with these cases that I think are not meritorious. They're just issuing the temporary orders. But other jurisdictions do have what we call the 72-hour hearings. 72-hour hearings do not require notice to the offender or to the alleged abuser. They only require that the petitioner or victim appear before the court. The Second Judicial District typically is scheduling hearings outside of the 10 days because they're handling such a magnitude of cases. So we frequently in Albuquerque get cases that are set 3 and 4 weeks out. That is not clearly authorized under the statute, but the court says good cause exists to extend the length of the temporary orders of protection, the temporary restraining orders, because we don't have the time to hear all of the cases that are requesting hearings within the 10 days. Most other jurisdictions do not have that problem. So please be aware, if you're going to refer cases to New Mexico Legal Aid for representation, please be mindful of the fact that requesting legal assistance from us close to a hearing may result in your client or the person that you're working with not being represented, because we simply ethically cannot prepare for a case with little time. Our cutoff is 72 hours. So if you have a hearing that is scheduled less than 72 hours from the time that you're sending us a referral, we will kick that case back to you and we will ask you to secure a continuance for that client so that we can consider them for representation. If the client does not want to seek a continuance, they will not get representation at that hearing. Okay, so there are 2 types of orders of protection. There are stipulated orders of protection, and there are orders of protection with a finding of abuse. And I just want to point out that down here, none of these orders of protection are valid until the offender has been personally served with that paperwork, whether it's an emergency restraining order, a temporary restraining order, or an order for protection. So there will be no hearing on a temporary order of protection if that order of protection, the temporary one, has not been served on the respondent. And same with the emergency restraining order and the order for protection if it's granted on a default. So if you get somebody served on a temporary order of protection and then they default to the hearing, the court will still issue the temporary order, the court will still issue the order for protection, and what I call an extended one. But that order for protection is not valid until that person gets served with that order of protection, which is why the courts will issue arrest warrants for the offenders for failing to appear. So what is the difference between a stipulated order for protection and an order for protection with a finding of abuse? So a stipulated order for protection is something that the respondent agrees shall be entered against them. So it's very similar to pleading no contest in a criminal case versus pleading guilty. So there's no evidentiary hearing, and the court is making no finding of abuse. So they're not saying, yes, I believe this victim's testimony, and I am finding that an act of domestic violence has occurred. With a stipulated order of protection, it is not necessarily going to have an impact on custody. It might mean something in the criminal case, but probably not, okay? It is similar to the order for protection with the finding in that the same gun regulations federally apply. It's the same in terms of enforceability with law enforcement. It has the same restrictions, so staying 100 yards away from that person's school, work, or residence, 25 yards in a public place, etc. And neither the stipulated order for protection or an order for protection with the finding have any limitations on the length of time that the court can issue that order for protection. So, for example, just this morning I was in court. The opposing party agreed to a stipulated order for protection for a period of 5 years. If the parties have children, you would do, in either instance, you would do a custody attachment, and the custody attachments are only valid for a period of 6 months. Some courts, so I've put a star down here, some courts think that they only have jurisdiction to issue an order of protection, whether it's stipulated or after a hearing, for a period of 6 months. Those courts are incorrect. And at Legal Aid, we have been trying to flag the jurisdictions that think that, so that we can enter on those cases and then litigate the length of an order of protection, so that we can convince the court that they have an unlimited period of time to issue an order of protection. So Julia Petroselli, one of the attorneys in our office, just got a 50-year order of protection. There is no requirement that orders for protection have expiration dates. However, law enforcement doesn't like to enforce orders that don't have expiration dates, even though there's no requirement that they have expiration dates. I don't know why that is. I can guess that it's because cops like to have certainty. The case that Julia was in court on this morning, the client had a order for protection issued out of McKinley County that was granted in perpetuity. And the client had one heck of a time getting law enforcement to enforce that order for protection. So we went ahead and got her an order for protection issued out of Albuquerque that's valid for 50 years. So it'll be in place until she's in her 90s. So the restrictions, gun restrictions mainly apply for that entire time. So in an order of protection that's been issued for 50 years, somebody is not allowed, the respondent is not allowed to have guns during that 50 years. Now, and I'll talk about the new New Mexico law as it applies to guns in a second. So, mutual orders for protection. There is no such thing. So, if you have a client who goes into court and the opposing side has a lawyer and the lawyer says, hey, let's enter a mutual order for protection. Unless that respondent has filed a counter petition, the court cannot, period, stop, do not pass go, cannot issue a counter order of protection. Okay? So it goes petition, counter petition, order of protection against respondent, order of protection against petitioner. There's no mutual orders for protection. It used to be that the courts would have litigious people and be irritated by them and just issue a mutual order for protection. Federal law prohibits that, and New Mexico law prohibits that. Sometimes people need an order of protection entered against them. So, for example, I can think of a case where the husband is clearly the more abusive person, physically and emotionally, but the female, the wife who we represent, constantly engages with him. And every time he baits her, she takes the bait. So she has engaged, she's stalked him. She has texted him in violation of a temporary order of protection. She needs to have an order of protection entered against her because, in my opinion, that will help her be clear that she is done with him. But in advising her that she might need that order of protection entered against her, she is also then potentially exposing herself to criminal liability if she continues to engage. So if you think that your client will continue to engage, then perhaps you would do best to advise her to dismiss it and see if you could get the other party to also dismiss. And then that might be a situation where you enter into a no contact order as part of the domestic matters case, because it's essentially issuing a stern warning to each party that they need to not have contact. Now, we do represent respondents on occasion where the petitioner is actually the abuser, but they have beaten, not literally, but sometimes they have literally beaten the victim to court. So sometimes it's a race to the courthouse. And one of the things that we have noticed out of the Second Judicial District is that they're declining to issue temporary restraining orders that address custody. So why do we care? I mean, we care because if the offender, let's say that the offender fled the scene on the night of a domestic, takes the kid with him, and races to the courthouse the next morning. Let's say the victim is in the hospital, for example, and law enforcement, for whatever reason, didn't charge the offender that night. He races to the courthouse and he gets a temporary order of protection against the victim, and he gets custody of that kiddo. The victim could, let's say, go into court the day that she gets out of the hospital, file a counter petition containing the real allegations of domestic violence, and ask the court to award her custody of that kiddo back. And law enforcement would be required to go out, pick up the kid, give the kid back to the real victim. But the Second Judicial District has been declining to do that. So what that means is that nobody has custody and possession is 9/10 of the law during that temporary order of protection time period. And the temporary orders of protection we're seeing being issued out of the second for 3 weeks. So that's a problem. And Courts can issue pickup orders, and you can advise your clients to request pickup orders or file a motion for a pickup order. But really, that may not necessarily be a good idea. And so we would, if you're not a lawyer, we would ask you to contact New Mexico Legal Aid's legal helpline with any questions. And let me just, so Johnny Trujillo, Johnny is out of the, he's the executive director of the shelter in Socorro. He has 2 questions. Does personally served mean served by law enforcement? No, personally served means that the respondent has been handed the court paperwork. Anybody over the age of 18 can serve the respondent, so long as it is not the petitioner. And so, are you guys hearing my answers?
Yes, we can hear them.
Okay. So personally served means that the respondent has been handed the paperwork. Johnny Trujillo also comments that law enforcement is wanting an expiration date because of NCIC. NCIC is the national, I can't remember what it stands for, National Crime something or other. It's the national database where orders of protection are entered. Now, Blanca Perez asked, if a victim is in the hospital or unable to file personally, can someone file on their behalf? It depends. I think that probably they could ask a next friend, and I'll type the answer here just so that you guys see what the term that I'm using. Next friend is somebody who could file on behalf of, and so you will see that written as OBO. If one were to do that, you would want the caption to say, you know, Jane Smith on behalf of, you know, Barbara Smith, and put in the petition, I am Jane Smith. I am Barbara Smith's sister. Barbara Smith is in the hospital in a coma, but before she went into a coma, she told me that he did it, and I want to get this order of protection on her behalf. The court should allow that. They don't always allow that. So if you're finding a situation where the court is saying, nope, victim has to be awake and come down and petition herself, give us a call and let us know. But typically they have to do it themselves because their statements have to be attested to and signed and notarized. I don't think they have to be notarized, but the court clerks have to see that person because they check their identification. I have seen instances where victims have been in the hospital and the victim advocates have gone out and notarized their statements and brought them in, but those are pretty special circumstances. So in order for protection with a finding of abuse. So a finding of abuse is a specific, what we call term of art, meaning that it's a specific phrase that you find in the law. And what it means is that the court, it's basically a finding of guilt. So basically the court has listened to the evidence and said, I believe that an act of domestic violence has occurred and I'm making a finding of abuse. So what that means is that findings of abuse can only occur after an evidentiary hearing, meaning that the victim must testify. There must be testimony put forth that allows the court to make a finding of abuse. So they have to hear evidence. And some people think that it's beyond a reasonable doubt. That's a criminal standard. It's preponderance of the evidence, which means 51% likely that an act of domestic violence occurred versus not. So it's a pretty low standard. But major caveat here, every commissioner is different. So even though they are trained on what the standard is, what the burden of proof is, some of them believe it's higher than that. So for example, we have a commissioner in the 2nd Judicial District. He thinks it's reasonable doubt. So if I'm going to go and do a hearing in front of him, I'm going to subpoena law enforcement, maybe a SANE nurse, photographs, eyewitnesses. I'm going to subpoena as many people as I can because it's very difficult to get an order of protection in front of this commissioner based just on the victim's testimony. In fact, it doesn't happen really at all. And we file objections against him. We actually just had a court of appeals say that he should have found that an act of domestic violence occurred. So be aware of who your commissioner is. And for you advocates, if you have a question about a commissioner, most of our legal aid lawyers, there are about 50 of us statewide, most of us have appeared in front of many of the commissioners in your jurisdiction. If you have a question, you want to give a client pro se advice, call us. We'll tell you what we think. Now, findings of abuse are very important to custody cases. If I have a custody case that is a companion case or there are kids, I may push for a finding of abuse because New Mexico law prefers joint legal custody. What does that mean? Joint legal custody is not physical custody. Joint legal custody is says that the parties shall share all decision making. So legal custody refers to decision making, not physical custody. So legal decision making relates to religion, school, physicians, and physicians can include medical and mental health treatment. So counseling, for example, schools, religion, medical, extracurricular activities, and residence, meaning where is that child going to live? And remember that abusers will use joint legal custody as a way of vetoing any decisions that the custodial parent might want to make. The most prevalent example I see of this is abusers who veto a custodial parent who is requesting that a child get mental health counseling, whether it's for witnessing abuse or having problems dealing with parents getting separated, whatever that issue is. So in a case where there's domestic violence, I try as a strategy to get that finding of abuse, because when there is a finding of abuse specific to domestic violence, whether it's domestic violence against the mom or domestic violence against the kid, the court has to take that into consideration, and it rebuts the presumption that the parties should be awarded joint legal custody. And that's very important. So if you have a case where there's a criminal case and you think that it's a pretty good criminal case, the criminal case judgment, whether it's a plea or after trial, also rebuts that presumption. It equates to a finding of abuse. I'm trying to think, if the victim really doesn't want to testify, obviously you're not going to necessarily be able to talk her into doing that just for the purpose of getting a finding of abuse. But, and for example, in defaults, many times the courts won't let you put on a hearing anyway. So even if you want the finding of abuse, they may not let you do a hearing, but you can request in defaults that the court make a specific finding of abuse based on the testimony or the statements contained in the petition, because you want that finding of abuse to rebut the joint legal custody. Orders of protection with a hearing can be helpful to the criminal courts, meaning that if the offender respondent gets up and makes a ton of admissions about the domestic violence, that can be used by the prosecutor. It can also be a good environment in which to let a client kind of do a dry run of their testimony, sit in the courtroom, see how it feels to testify against that person. And the district attorney might use that testimony because it's under oath and it was subject to cross-examination, and that makes that testimony admissible in a criminal case, particularly if for some reason the victim decides she doesn't want to participate in the criminal case. So if you think that your client might reconcile with the person, but you still think that the guy should be prosecuted, maybe you want to encourage your client to testify at the evidentiary hearing, because again, usually the evidentiary hearings are much closer to the date of incident than the criminal cases are. I'm just going to check here for questions. I don't see any. Okay. So custody attachments. As I referenced in the first slide, custody attachments, the court can only do custody for a period of 6 months. In Albuquerque, it's pretty typical that the court will do a custody attachment for 6 months and an order of protection for a year. In Albuquerque, you can usually get the courts to extend the custody attachments for good cause. So let's say that you file a paternity or a divorce case and you're unable to get that person served in the time frame that you need. You might want to seek an extension on that. The Uniform Child Custody Jurisdiction and Enforcement Act, UCCJEA, what I'm referring to here. So I'm going to type that out so you guys, I'm going to type it out in the question and answer portion just so you can see what I'm talking about. So the Uniform Child, oh, it looks like I can't just type that, but okay. So Uniform Child Custody Jurisdiction.
Edna,
Yeah.
If you can type it in the chat, or
Yeah.
send it to me, I can put it in the chat. That's a way that you can just type it.
Why? Oh, chat. Okay, I'm going to type it in the chat.
Thanks.
Uniform Child Custody Jurisdiction and Enforcement Act. So what that means is that every uniform just means that every court, every state in the United States has adopted the Uniform Child Custody Jurisdiction and Enforcement Act, meaning that the terms are the same across the country. And the UCCJEA is super complicated and you don't need to worry too much about it, except that it's very important for clients who are fleeing from, let's say, Texas to the state of New Mexico. If you have somebody that shows up in your shelter or is calling your hotline and says, I'm staying at the hotel, I fled El Paso, Texas in the middle of the night, what do I do? That person needs to go immediately, like they need to hang up with you and go straight to the courthouse and file for a domestic violence order for protection, alleging and outlining that they have fled because of domestic violence. And the court can, under the UCCJEA, take emergency jurisdiction. An emergency jurisdiction says that if the mother or the custodial parent is fleeing domestic violence or some kind of abuse or harm or threatened harm to a child or to that parent, so the harm doesn't need to be aimed at the children, they can flee a jurisdiction and ask a court of another state to give them legal authorization to be in that state with those children and not get charged with parental kidnapping federally. So the UCCJEA is extremely important for you as advocates to understand. And so all you need to understand, and I'll write this in the chat. All you need to understand is that the UCCJEA, it allows victims to flee one state and move to another on an emergency basis and have custody of the children legally. Thus, they cannot be charged with parental kidnapping or custodial interference. Okay, so let me just say that again. So Roberta Radosevich asked whether or not it includes reservations. No, not unless the reservation has adopted a form of the Uniform Child Custody Jurisdiction Act. So that it definitely applies in state courts. I think it's possible, although I don't know, whether or not the reservations have codified something equivalent. I would venture to guess that probably Navajo Nation has, or maybe Zuni. Some of the more progressive tribal jurisdictions have probably adopted something very similar that allows that court to take emergency jurisdiction over the custody of a child based upon an emergency. And again, an emergency can be harm or threatened harm to the custodial parent or to the children, or both. So let me go back to the PowerPoint. So again, under domestic violence orders of protection, the custody attachments are only valid for 6 months. JX is lawyer shorthand for jurisdiction. So most jurisdictions will extend that 6 months based upon good cause. So again, good cause would be something like we weren't able to get this person served with the parentage action, etc. And remember that the custody attachments set the tone for any parentage case. So what am I talking about? So let's say that your client is saying to you, he's abusive to me, but he's a great dad. And I want to give him 50-50 custody of our 1-year-old. And let's say that you think that that's a great idea, and you have them enter into that as the custody attachment in the domestic violence case. And then 3 weeks down the line or a month down the line, it becomes clear that this is a really, really bad idea, because 1-year-olds shouldn't be away from mom that long, and opposing party is using that to, contact mom, for example, like messaging every day, like, what diapers does kid use? What diaper cream? What food? Da 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 da. But really, they're doing it to say, like, where are you? Who are you with? Those kinds of things, for example. You are going to have a hard time getting that visitation schedule overturned or changed in both the domestic violence case and in the companion divorce or parentage case. So I always try to have a real education with my clients about, first of all, why abusive parents who commit domestic violence, why those parents are not good parents to kids. Because they're not. I mean, maybe that's a bias of mine, but I just don't think that they are. And what I use to educate clients in a neutral way is I talk to them about adverse childhood experiences, and I point out kind of the long-term ramifications of kiddos who witness violence. So even in a case where it's a 1-year-old who, supposedly hasn't seen any of the domestic violence, I point out all the long-term ramifications of even being in a home where domestic violence occurred. And then I say, we're going to do, frequent short visits, supervised exchanges or supervised visitation. And I try to always stick to the least amount of time, because it's easier to give more time. It's harder to give away the farm and then get the farm back when things go south. So in a situation where I get a custody order that I like and that works for my client, I will file a parentage or a divorce action, or have the client do it, and have the client ask that the domestic relations court adopt the domestic violence court's custody attachment. Now, in some jurisdictions, those are the same judges, the same hearing officers, the same person who's adjudicating the case. In Albuquerque, we have 3 to 4 hearing officers plus, are there 4 judges? Lavelle, Levy, Amber Baker, and Ramirez. Yeah, so in Albuquerque, there are 4 judges. So the judges they're not necessarily the same person who heard the domestic violence case. So just remember that whatever you decide in the custody attachment can have long-term ramifications in the divorce case or the custody case. And remember too that just because there's a no contact order, even if the no contact order is valid for 10 years, if the custody attachment expires, there's no custody order. And in New Mexico, possession is 9/10 of the law. So if the client doesn't want to file for parentage, you need to make very clear that they understand that after the expiration date of the custody attachment, if the offender shows up at daycare and takes the kid, they're SOL. And again, we are always happy to advise clients of that. Okay, so credible threat. And how many, well, it's probably not worth it to ask how many of you have dealt with this, but credible threat is a term of art, meaning that it's in the statute, the Family Violence Protection Act. And let me just, I know you guys are looking at my screen, but let me just kind of show you where it is in the statute. So it was passed it became effective July 1st, 2019. And it came about because the legislature in New Mexico wanted to create a law that made state law in New Mexico that possession of a gun by somebody who had an order of protection against them was punishable as a criminal offense. And the courts also, realizing where New Mexico ranks in domestic violence, wanted to create a mechanism for domestic violence courts to force people to turn over their guns because previously there was no mechanism for that. And federal law, while federal law says, yes, it's a federal violation to possess a firearm, there was no mechanism for that to be affected, meaning that the courts couldn't say, hey, law enforcement, so-and-so, you need to turn over you need to take possession of this person's gun. So can everybody see the statutory section that I've pulled up here?
No, we're still looking at your PowerPoint.
Okay, so I'm going to just jump over here. Now, can you see it?
Yes.
Okay, so if you look here, this is 40-13-15, okay? So if you look at paragraph 2 and A and B, it says, if the order is issued pursuant to this section and the court also determines, so in addition to a finding of abuse, the court also has to determine that the restrained party presents a credible threat to the physical safety of the household member after they've received notice. The restrained party is ordered to deliver a firearm in their possession, care, custody, or control to law enforcement. And they're restrained from purchasing, receiving, possessing, or attempting to attempt to purchase, receive, possess any firearm while the order of protection is in place. So anybody who is found in violation of that can be charged criminally with possessing a firearm. But this paragraph sets out that the courts, the hearing officers, or the judges shall consider whether or not somebody is a credible threat. So what happened was the court then, prior to this being made law, adopted forms, meaning that the new petition says, does this person present a credible threat to you as the victim, the person seeking the order of protection? But there was not a lot of teeth put into this law in terms of enforcing if somebody does not turn over their handguns. And that's no fault of the legislature. You know, as you can imagine, the gun lobby, you know, responded in kind. And a lot of the, if you all recall, the Sheriff's Association had a lot of sheriff's departments saying, we're going to declare ourselves a sanctuary jurisdiction and we're not going to enforce this. Meaning that they weren't going to take possession of anybody's firearms, and they weren't going to presumably charge somebody who they came into contact with that was in violation of this. Which is a whole nother different philosophical debate about the legitimacy and the legality of that. But nonetheless, some law enforcement agencies are not enforcing this. And each court seems to be applying what credible threat means, and what a petitioner, what evidence a petitioner needs to present to the court in order to have the court make a secondary finding of a credible threat. So credible threat is a second finding to the first finding. They're separate findings. So the first finding is a finding of abuse, and the second finding is credible threat. The court can make a finding of domestic abuse and not find credible threat, or they can do both. And can one stipulate that they are a credible threat? Yes, one can stipulate that they are a credible threat. I don't know why one would, but I don't know why one wouldn't. If they didn't want any kind of a record that they were a threat to this person, whether it's because of a gun or because of an act of domestic violence, I think that they might want to. But a lot of people, like the guy I was in court on this morning, he was willing to stipulate to an order of protection being entered against him. But when I asked him if he would be willing to stipulate that he is a credible threat, he freaked out because he doesn't understand. And I'm not his lawyer. I'm not going to explain it to him. So I got the stipulation to the order of protection and didn't left the portion about credible threat blank. So it's something that we're learning as we go along. Let's say that they stipulate to the order of protection, but they're not willing to stipulate to the credible threat. I've had the court schedule it for hearing on just the credible threat. So what testimony, what evidence is necessary? The Second Judicial District has promulgated these elements. And I think that these are good elements because they kind of cover all the ways in which we know as domestic violence providers that increase lethality, that are on lethality assessments. And I see a typo, but so those was a gun used in the incident of domestic violence? Does the offender have access to guns? Does the offender have a violent criminal history? Have they made threats of suicide? Are there other acts of desperation? To me, acts of desperation would be reaching out to family members saying, please tell her not to leave me, showing up at her work, stalking probably, pervasiveness of power and control. So we know that some offenders behave more holistically in their imposition of power and control. Some of them are not that savvy. Seriousness of violence alleged, and I spelled it wrong, valence, but I mean violence, seriousness of violence alleged, including stalking. So even though stalking is a misdemeanor, the courts in Albuquerque want to know whether or not there's stalking, and has the relationship recently ended. I think too, another important element, although the courts haven't said this, but another important element would be, is your victim pregnant? If your victim is pregnant, we know that that increases lethality, okay? So I would put this evidence on either in a hearing all by itself on credible threat, or as part of the case in chief on whether or not an act of domestic violence occurred, were I also seeking that that person be found to be a credible threat. And I've done it both ways, and I've won on that issue. Not every victim identifies that their offender has a gun. So I think in terms of consistency, we should not be asking in every case that somebody is a credible threat if they don't own guns, for example. Okay, so let me go back to my PowerPoint. And so and I know I'm almost done actually. I only have 11 slides. So 40-13-13 of the statute says that they shall relinquish their guns within 48 hours to a law enforcement agency. Each court seems to be applying this differently. So for example, in Albuquerque, where there are two agencies, APD and Bernalillo County, there's no consistency across the law enforcement agencies. LEA stands for law enforcement agencies, about where the gun goes, who's going to store them, who pays for the storage, how do we track that evidence. So if you have Bernalillo County Sheriff's Department saying we're not going to enforce that, then it would seem to imply that APD is responsible for it, but APD says that they don't have the storage to control all of these guns, or take control of all of these guns. And I can't remember, I think Judge Ramirez here in Albuquerque told us at a recent meeting that they have in fact had, I think, 30 surrenders of firearms. So in my opinion, one person surrenders one gun. That means that the law is working because that's one less gun. But, you know, the cops don't really feel like their abilities to store or execute warrants, for example, was taken into consideration when this law was written. Every law can always be improved, so hopefully that will be a community task that we endeavor in the coming years to include law enforcement in those assessments. And hopefully we can get law enforcement to understand that we're not taking away rights that just for no reason. We are taking away rights, one, that the feds have already said will be taken away, and two, we know what guns do in domestic violence relationships. So it's not just, hey, we don't want you to have guns, we're going to take them all away. It's based on empirical evidence that says that when there's a gun in the home, domestic violence victims get killed with them. So violations of an order of protection. There are two options: notify a law enforcement agency or notify the court. If you notify a law enforcement agency, they shall enforce. So what does that mean? It means that if they have probable cause to believe that a violation of the order of protection has occurred, they shall charge that offender. If the offender is on scene, they shall arrest them and charge them with violation of an order of protection. Now, technically, they should charge them if the person doesn't pay child support, but they're not going to. So that would be a situation where I would notify the court if it was a non-payment of child support. But if it was driving by their house, notify law enforcement. On 2 or more incidents of violation of an order of protection, that bumps it to a felony of aggravated stalking. Not every law enforcement agency is hot to trot on these kinds of charges. It's a training issue, in my opinion, and some years cops do better than other years. It just really depends. You know, I'm always happy, as are I think probably any attorney at Legal Aid, is happy to talk to you about when you would advise a client to file in court versus notifying law enforcement. But my preference is always notify law enforcement. When you notify the court can't really do much other than hold that person in contempt. And contempt generally doesn't carry jail time. It might include a monetary fine, but I honestly can't think of a case where I've had that happen. So remember that if your client files a motion alleging violation and the court hears that and decides, yay, a violation did occur, or nay, a violation did not occur, either way, the second that the court decides that issue on the facts, double jeopardy is attached. And what that means is that the court's, law enforcement cannot then go in and charge that person with a separate crime. So that's the logic behind that. I wanted to give ample time for conversation. So my last slide is really about how to access New Mexico Legal Aid. We have a generalized main intake line. We help with all kinds of different things. Give us a call. But specific to domestic violence, you can call our helpline. That's Monday through Friday from 9 to 5. Lawyers answer that. So if you have a question as an advocate and you just want to ask one of our lawyers, you can call that helpline. Many of you are so-called CYFD shelter partners, meaning that you already fax us referrals. So that's one way to access legal aid. We also have an LGBTQIA specific violence grant that's statewide. So if you have a trans client who doesn't feel comfortable talking to me, they can call our 1-877 number or email safe to be you. We also have out of Albuquerque specific First Nations trafficking and or domestic violence referral sources. And by Zuni, I mean Zuni. I don't mean Zuni Pueblo. I mean the street Zuni in Albuquerque. First Nations is a community healthcare based agency, and they have clinics on Zuni and San Pablo, I think, and then on Truman and Lomas. So clients can access New Mexico Legal Aid for help with sex trafficking and or domestic violence at either one of those locations. And of course, you can always email me. Let me go back to the very first slide so that you know how to get a hold of me directly. So this is my direct telephone number and this is my direct email. Like I know, for example, that I owe Johnny Trujillo a call. And so, sorry, Johnny, I will get to you. I apologize. You know, sometimes it's easier to get a hold of me than other times. But again, there are a multitude of lawyers within our organization who do great work and are available. So at this time, I will open it up to questions. I just want to say that I see that there are 70 some odd participants. That is awesome. That is so exciting. I'm so happy to see you guys.